In this lecture, we'll walk through NYAMENEBA's judgment in a case where a religious sect said they used herbs of life, but the state said it was Indian hemp. The interesting part isn't just the facts, it's how the court handles scientific reports, cross-examination, and the difference between mistake of fact and ignorance of law. Start with the basic path of events. The appellants lived in Princesstown. Conflict escalated on Christmas Day, 1963, and the matter went from the chief's intervention to the police at Agona, then to the farm where the plants were grown. They were tried at Takoradi, convicted, and then appealed, where the legal reasoning became decisive. The indictment had multiple counts. All of them were charged with cultivating Indian hemp, some were charged with possessing it, and some with smoking it. So the court had to decide not only what the substance was, but also whether the legal elements of each offense, especially the mental element, were actually proven. Notice cultivation is the common thread. Every appellant faced that count. That matters because the trial judge treated the case as if the only question was permission and legality, rather than whether the accused knew the nature of what they were cultivating and using. Factually, the appellants belonged to a religious sect and said they'd used certain herbs publicly for 4 or more years. They burned it as incense during worship, cooked it into soup, and boiled it as medicine for ailments, claiming success. They said the herb was spiritually discovered and called it the herbs of life. One appellant's evidence captures their belief system. He described himself as a farmer, said smoking the leaves gave him wisdom and strength, helped him live morally, no stealing, no false evidence, and even claimed a biblical reference in Genesis. Whether persuasive or not, it shows genuine belief about what the substance was and what it did. The point of highlighting this is not theology, it's legal context. They framed their use as moral and religious, not as ordinary drug use. That framing later connects to whether they honestly, but mistakenly, believed they were using something lawful and beneficial. The sect publicly condemned the chief, elders, and especially the youth for alcohol and cigarettes, saying those practices lead to bad lives and block heaven. In contrast, they preached that abandoning drink and cigarettes and using the herbs of life would lead to salvation. This public confrontation is what set the social conflict in motion. On Christmas Day 1963, town elders complained to the chief and asked him to stop the sect's conduct, which outsiders experienced as harassment or nuisance. The chief sent elders to remonstrate with several appellants, but the interaction backfired because the appellants responded by demonstrating and smoking the herb in their presence. The evidence shows suspicion grew socially, not scientifically. The elders didn't truly know what the substance was. They suspected it based on what they'd heard. The group went to the chief's place, then back to a house where more sect members produced more of the herb, and ultimately the chief sent them to the police, who then visited the farm at the appellant's invitation. That detail is crucial. The villagers' evidence was essentially suspicion. It helps explain why the chemical analysis mattered, but also why the core legal question became the appellant's knowledge, because even the community couldn't confidently identify the substance by observation alone. At trial, the prosecution tendered a chemist's analytical report certifying the herbs were Indian hemp. The appellants didn't object to the certificate being admitted, but they insisted it couldn't be their herb. They asked for the chemist to appear so they could cross-examine him, hoping to show their herbs of life were different. The circuit court actually directed that the chemist be called, and the case was adjourned. But on the next date, the state attorney said the chemist was not in the country, and he did not wish to call him. NYAMENEBA described that stance as most unfortunate, because prosecution responsibility doesn't end with simply tendering a certificate. This is where the judgment signals a broader principle. When a defendant challenges a scientific report, fairness may require the author to be made available for cross-examination. The prosecution can't treat a certificate as the end of the matter if the defense is actively disputing it. Section 121 of the Criminal Procedure Code allows certain scientific reports by government medical practitioners, analysts, chemical examiners, and others to be used as evidence of the facts stated. The key word is may. The court interprets that as making the report prima facie evidence, acceptable at first glance, but not automatically conclusive. That single word drives the interpretation. If a report were conclusive, cross-examination wouldn't matter. But because it's only prima facie, a defendant is entitled to challenge it. Section 121(5) complements that idea. After receiving such a report, the court may, if proper for the ends of justice, summon and examine the analyst or cause evidence to be taken on commission. so the system anticipates situations where live testimony is needed to ensure fairness, especially when the report is disputed. NYAMENEBA also notes a practical point. Because the substance was still available, another chemist could have analyzed it if the original analyst was unavailable. The broader message is procedural fairness. When a report is challenged, the prosecution should support the court's effort to test it, not resist it. Interestingly, the Supreme Court still says, despite the prosecution's refusal and the circuit court's failure to call the chemist, there was no miscarriage of justice in this particular case. Why? Because even perfect oral evidence from the chemist wouldn't change the core defense issue, what the appellants knew at the relevant time. The judgment's logic is that learning the truth during trial doesn't retroactively create guilty knowledge at the time of cultivation, possession, or smoking, so the chemist's live testimony might have educated them, but it wouldn't supply the missing legal element for conviction.
A key factual feature, the appellants admitted cultivating, possessing, and smoking the substance produced in court. They even voluntarily showed it to townspeople and later to the police, and invited police to the farm. So the case was never about whether they physically had it, it was about whether they had the legally required knowledge.
The circuit judge accepted the chemist's report and concluded the tree of life was Indian hemp, but he convicted on reasoning focused on lack of ministerial permission and on the accused failing to prove lawfulness. The Supreme Court criticizes this as a misconception of the real issue because the mental element was not properly addressed. The appeal turns on Section 29 of the Criminal Code. Subsection 1 says a person isn't punished for an act if, due to good faith mistake or ignorance of fact, they believe it lawful. Subsection 2 says ignorance that an act is prohibited by law is not a defense. The task is classifying the appellant's ignorance, fact or law. This is the classic distinction. Mistake of fact can negate liability. Mistake of law generally doesn't. The court emphasizes you must take both subsections together because they codify that general principle rather than letting one subsection swallow the other. The appellants were charged under Section 49 of the Pharmacy and Drugs Act 1961, which imposes absolute prohibition on cultivating, possessing, or smoking Indian hemp. The court notes, nobody can be heard to say they didn't know such a law exists as a general matter. So if the claim were, I knew it was hemp but didn't know it was illegal, that would be ignorance of law. The Supreme Court draws a sharp line. If they knew it was Indian hemp but didn't know the law prohibited it, Section 29(2) would apply, no defense. But their consistent claim was different. They honestly didn't know the fact that the herb was Indian hemp at all. That falls under Section 29(1), mistake of fact in good faith. A central holding is that the prohibition only bites, in the relevant sense, when the prosecution proves possession with knowledge. The court stresses that for offenses about possession of Indian hemp, it's not enough to show physical custody. The prosecution must also prove the accused knew the nature and quality of what they possessed. NYAMENEBA relies on a Marte v. the State for a detailed explanation. Possession under these provisions means possession with knowledge, awareness that the article is opium, Indian hemp, or residue. Physical possession without that knowledge is no offense. So the prosecution must prove knowledge directly or by circumstances showing the accused knew or ought to have known.
This matters because the prosecution doesn't always need a confession. Knowledge can be inferred, say from concealment or warnings ignored. But in this case, the surrounding circumstances pointed the other way. Openness, public use, and consistent insistence it was a different herb.
Applying that test, the prosecution proved physical possession easily because the appellants admitted it, but it failed to prove the essential knowledge element. In fact, the defense evidence went further and, in the court's view, conclusively showed absence of that knowledge. They honestly, though mistakenly, believed they had herbs of life. The Supreme Court concluded the circuit judge misdirected himself by focusing on permission and legality rather than knowledge and mistake of fact. That misdirection caused a miscarriage of justice because it produced convictions without proof of an essential element. The court therefore allowed the appeals, quashed convictions and sentences, and entered verdicts of acquittal. To wrap up, first, scientific certificates can be used in evidence, but they're prima facie not automatically conclusive. Second, if a defendant challenges such a report, the prosecution and court should ensure a fair chance to test it. Third, and most important here, possession offenses require knowledge of the substance's nature, so honest mistake of fact can defeat liability.